Welcome, students. My name is Catherine Drabiak. I'm a professor in the College of Public Health, and I teach health law, public health law, and medical ethics. I'm also co-director of the scholarly concentration in law and medicine. Today, we're going to be talking about what new physicians should know about Florida's abortion law. To get us started, this is an educational presentation. It's not legal advice. We're going to talk about the physician's role. We'll explain the history of abortion law and then get to the recent case of Dobbs versus Jackson. We'll talk about different approaches that states take to abortion law. Then we'll talk about Florida's abortion law. And finally, we'll go over some common terms and other considerations that you might see as future physicians. So what is the physician's role? Abortion is really a profound moral and social issue. People hold very different opinions about it. So independent of your personal opinion, the law gives very specific directives of what physicians can or can't do when it comes to providing or not providing abortions. So your future role as a physician is to communicate with your patients as a trusted source of information, of authority, and give them clear, straightforward, non-misleading information. This applies both when you're speaking directly to your patients, but also statements that you might make to the media, if you write op-eds, or even any academic papers that you write. It's important to distinguish what the law is versus concerns or policy ideas you might have about what the law should be. Separate this and accurately counsel patients based on what the law is in your state. So to do this, we're going to walk through the evolution of abortion law and then talk about how the law regulates the profession of medicine. Sometimes you might see newspaper headlines that say that the law should stay out of the practice of medicine. Well, they haven't met health law professors. It's important to keep in mind the law regulates a lot of things in medicine, not just abortion. So this can range from mandating the hours that you spend in medical school, what your curriculum is, to even requiring informed consent when you start treating patients and engaging in certain procedures or not. So for example, making certain requirements for prescribing medications or prohibiting you from doing certain things, like in a majority of states, prohibiting physician-assisted suicide. So what's the purpose of these laws? Well, it's to make sure that physicians are well trained, that you're providing safe, adequate care in clean facilities. And most physicians are exemplary at this. You would never knowingly harm your patients. But these regulations provide guardrails both for your patients and your profession. You have a fiduciary duty to your patients. You have specialized knowledge and skill, and your patients trust that you act in their best interest. They rely on you. For an unbelievable story where this goes terribly wrong, you can read more about the criminal atrocities committed by Dr. Kermit Gosnell, pictured here, a physician who provided abortions to a clinic in Philadelphia. So what's the history of abortion? For about 185 years, the practice of abortion was regulated individually by each state. The vast majority of states prohibited it. It was a criminal act. Early treatises said that if a person's actions, like a physician, caused an abortion, for example, by giving a medication, this was a homicide. Most states only permitted abortion if the physician determined that the pregnancy threatened the life of the mother. Some states started to have broader health exceptions. Around the 1960s, different social reformers set out to try and change the law and public attitudes. By the 1970s, about 30 states still restricted abortions for elective reasons. In 1973, Roe versus Wade started to set a national standard for abortion. That is, something would apply to all of the states. It was trying to settle this matter of national controversy. Roe versus Wade said that a pregnant woman has a right to obtain an abortion prior to viability, which is about 23 to 24 weeks. This case said that the right to an abortion was encompassed within broader rights of privacy, privacy emanating but not explicit in the Constitution. Roe versus Wade balanced this privacy right against what the court called the state's interest in protecting potential life. The Supreme Court said that these interests shift at the correlation of the point in pregnancy at viability. So, all states had to permit elective abortions before viability, and after viability, some states regulated it differently. States could choose to restrict it as long as there was still exceptions to protect the life or health of the mother. Some states do this and did this, and other states did and still do permit abortion until birth for any reason. In July of 2022, the Supreme Court issued a ruling in Dobbs versus Jackson. Dobbs versus Jackson, about 50 years later, was a case that looked at an abortion law in Mississippi. In 2018, Mississippi had passed a law that restricted elective abortions to 15 weeks. It had exceptions for abortions after that time for things like medical emergencies or fetal anomalies. But an abortion clinic challenged the law, saying this directly conflicts with Roe versus Wade. The Supreme Court overturned Roe versus Wade and said that the Constitution does not give people a right to obtain an abortion. The court looked at the concept of privacy rights and then this other legal concept called substantive due process, which is a liberty interest, and said Roe versus Wade was actually decided incorrectly based on interpreting these principles from the Constitution. Now, the idea of liberty in the Constitution and constitutional rights, where does this come from? The court said, well, we have to look at the history and tradition of these rights throughout the founding of the United States. And the court said obtaining an abortion did not meet this definition because in the nation's history, it was not a protected right, but it was instead a criminal act. It's important to understand that the Supreme Court does not make law. It does not decide what the law should be, but its job, as laid out in the Constitution, is interpreting the Constitution and interpreting the laws before it. This should sound like US government class. So, for policy issues where people have vastly different opinions, these are issues for the legislature, not the Supreme Court to resolve. This is not the Supreme Court's opinion. This is not my opinion. This is what the Constitution says. And what's the reason for this? Well, it prevents the Supreme Court or any branch of government from getting too much power. What does this case mean for you as future physicians? Well, the takeaway is there's no federal abortion standard or law. This case did not ban or prohibit abortions. What this case said was we're giving the power back to individual states to decide about their own abortion law. So this gives power back to the states and the voters to decide. Different people and different state legislatures will balance their competing interests in different ways. And this is what we see across the United States. About half of states have passed laws to restrict abortion. Many states are not trying to ban abortion, but instead they're changing the point in the pregnancy at which the abortion occurs, changing the gestational limits. A few states are trying to prohibit most elective abortions once the heartbeat can be detected at around 6 weeks. Every state still permits exceptions. For example, if they're necessary to save the life of the mother, these differ slightly depending on what state you might be practicing in. Other states have gone the other direction. They're trying to make it easier for women to obtain an abortion through different means, like allocating taxpayer funding for abortion services or mandating insurance coverage at no additional cost. Some states have also changed their laws to allow medical professionals who are not physicians to perform the surgical abortions. Now, this is a departure from other areas of medicine that usually requires physicians, based on their scope of practice, to perform surgical procedures. And this is tied to issues of patient safety. On this other side, about 8 states have a right that guarantee access to an abortion, and about 7 states, and this may change depending on the law, have no limits on when a pregnant woman can obtain an abortion, which means they can obtain one until birth from a willing provider. Another difference that you should be aware of is differences across state lines for treating adolescents who are seeking an abortion. In most healthcare decisions, children, including adolescents, cannot make their own healthcare decisions. States have narrow exceptions, like being able to consent to getting STD treatment, for example, but in some states, abortions, like other medical procedures, require adolescents to get parental consent. Some do, some don't. This differs depending on the state. If you or your future patients have seen some of the media headlines and messaging, it can be confusing, misleading, it might even scare your patients. So, here are some common questions or misconceptions based on these headlines that I've seen in the media. Remember, your role as a physician is to provide calm and accurate information for your patients. The first, laws don't criminalize pregnant women. Most states specifically reference the provider's actions and specify that any prohibition on abortion does not apply to criminalizing the pregnant woman. The next is Florida's law and other state laws restricting abortions do not encompass surgical procedures to remove a fetus after miscarriage or stillbirth. Many state laws actually define this very precisely in the law, and they talk about heartbeat or viable pregnancy when they're talking about prohibitions on abortions. And there are some stories, things even in people.com, if you read that, that make this very misleading. And it's important to make sure that as a physician, you would document the status of the fetus and the potential diagnosis, whether it was live or not living. Next, we've been over this point, and this is critical that laws do not prohibit life saving abortions. Every state has some type of exception that physicians can perform an abortion to save the life of the mother, and each state law is a bit different. But this would be another area for precise documentation. What is the emergency condition? What is the potential result if the procedure is not performed? What are the alternatives? And then what is the potential risk? And sometimes seeking a second opinion. Finally, pregnant women can always travel to other states. This is a constitutional right to interstate travel. Traveling from one state to another for medical reasons, social or personal reasons is also common. Here are some pointers for treating patients during an emergency. This would apply specifically to emergency department physicians. These types of physicians might have a mix of patients, those who are seeking an abortion, those who have experienced abortion complications, such as an incomplete abortion or hemorrhaging from surgical or medication abortion, and also women who are seeking post miscarriage care. These conditions and diagnoses would require different coding and billing. Coding and billing falls into the larger context of accurately tracking what services physicians are providing, what they are billing for, and then also when things might go wrong with different patients. These distinctions matter both for compliance purposes, but also patient safety purposes. For example, it's important to track things like, are there certain patients coming from one specific provider that have a high rate of post surgical complications and coming to you for follow up? Or are there patterns of patients experiencing certain adverse effects from medication abortions? Incorrect coding or billing, for example, indicating that it was a miscarriage rather than a complication from a medication abortion, might also violate the Federal False Claims Act. Now that you have all of this background information on general state laws, I'm going to turn to Florida's law. In 2022, Florida passed an abortion law that restricted elective abortions to 15 weeks with a whole list of exceptions. In 2023, Florida revised its law again, passing the Heartbeat Protection Act. This expanded pregnancy and parenting support services like counseling, parenting classes, and centers that offer baby items like diapers and clothing. The law also prohibits abortions after 6 weeks, with some exceptions. First, there is a medical emergency exception. If two physicians determine that the abortion is necessary to save the pregnant woman's life or health, here's how the law defines it. It says if the termination of pregnancy is necessary to save the pregnant woman's life or to avert a serious risk of imminent, insubstantial, and irreversible physical impairment of a major bodily function of the pregnant woman other than a psychological condition. If performing an abortion under this exception, the physician should document the exact diagnosis of the pregnant woman, what her symptoms are, and why the physician believes that this patient's condition meets this specific requirement. In this situation, you would be measured against the standard of care. What does this mean? This means what would other similarly situated physicians do in a circumstance like this? Would they also give the same diagnosis? Would they also say that this is an emergency? And the law requires two physicians to make this determination, which is a way to legally require a second opinion. Florida's law also has an exception for performing an abortion before the third trimester on the basis that the fetus has a fatal fetal anomaly. This is another area for documentation. What is the fetal diagnosis? Is the condition fatal? And documenting the gestational age of the fetus. There are other points to be aware of in Florida's law. Florida expanded more exceptions to include documented cases of rape, incest, human trafficking, and it strengthened reporting requirements to prosecute perpetrators of these types of crimes. As a practice point, physicians and also your care team has certain duties under state law to report suspicion of certain crimes like these in patients that you might see. This not only applies to abortion, but other areas of medicine as well. How does this fit in with health privacy and HIPAA? Well, HIPAA permits certain reporting of identifiable patient information, like your patient's name and some of their medical information, to certain authorities under a public health exception. Then every state law requires that physicians report certain information to appropriate authorities for further investigation. What does this mean? So this means reporting suspected cases of abuse to the Department of Family Services or reporting suspected cases of criminal activity like assault or human trafficking to law enforcement. And what this does is it helps the government agencies investigate and take further action if they think that a crime has occurred. This serves the function of not just protecting your patient who might be at risk, but also preventing this potential wrongdoer from committing further bad acts and hurting the public. Florida's law also requires a physician to perform the abortion. This is opposed to another provider like a PA or an NP. This is a regulation designed to ensure the health and safety of patients and reduce the risk of complications or physical risks that come from surgical abortions. Next, it also requires giving women medication for medication abortions in person rather than over telehealth. This intention is to make sure that the woman doesn't have complications that can't be monitored, like cramping, hemorrhaging, or incomplete abortion that might put her at risk of infection. Now, on the other side, telehealth increases access to some of these services, but at the same time, it can also create difficulties of patient follow-up or making sure that the woman is screened for coercion and that it's actually her decision. Lastly, for treating adolescents who might be seeking an abortion in Florida, Florida requires parental consent, or what's called judicial bypass. This means getting consent from a judge. Now, this can be an extension of general health law. Again, in most states, adolescents cannot consent to their own health care, and this Florida law is simply a reflection of that. Finally, federal law sets out what's called a conscience clause protection law. This is something that prohibits hospitals and other institutions from requiring a healthcare provider to perform services that might conflict with his genuinely held religious, moral, or ethical beliefs. This is actually a federal civil rights law. Many states, including Florida, have similar provisions. Now, these laws do not allow physicians to discriminate against patients based on age, race, sex, or national origin. There are a list of federal laws that already prohibit this. Instead, what this means is the physician agrees to treat the patient, but believes that a different service or treatment is warranted and that a particular service would violate his religious or personal beliefs, like abortion. You can read more about these legal protections for physicians on the resource slide. If you're interested, you can read more of the listed resources here. Thank you for your time and attention today.